Um, Good morning. It's Thursday, April 14th, 2021. And we're here this morning to discuss the backlog in the criminal and civil justice system and potential ways to use American Relief. I forget the name of it. The federal funds that are coming to us in order to deal with the backlog. The Judiciary has a very well done proposal, but if we do the Judiciary's proposal, it may be that we also need to help the defenders, the state's attorneys, the private bar, as part of you can't do one thing in one part of the criminal justice or civil. We're fortunate to have the Attorney General here, as well as the Defender General, and the state's attorneys will be here shortly. And we have Pat Gable representing the court administrator, or she is the court administrator. I'm fumbling this morning because I just came from a joint fiscal committee meeting, which one of the things we stay prepared for that mediation between laws, and then we'll go to the Judiciary, Defender General, and then the state's attorneys. See, John.
Me, but I think to our justice and public safety, public health, compared to the folks that are in the community awaiting an evaluation. And obviously you need that evaluation in terms of competency about whether or not a proceeding is going to continue. And how this works is, an allegation of a crime occurs, there's a screening and evaluation, and this is probably pre-pandemic, so I know it's changed. And whether it is a inpatient or an outpatient, the court can't order anybody inpatient unless the evaluator recommends that. But obviously during the pandemic, we now have 130 folks who are awaiting these evaluations. I think raises issues of due process, raises issues of obviously public safety and public health. And DMH, so the court orders the evaluation. The Department of Mental Health then hires evaluators in order to conduct these evaluations. And right now, and I'm just going to pull up my notes, I apologize. So one of the issues, and hopefully, as I said, I've talked to Judge Grierson, I've talked to Matt Valerio, I'll talk to John Campbell and Commissioner Squirrel as well, that we can all get together, because it's not going to be just as simple of saying conduct evaluation. We need to figure out how this is done remotely, and there may be a need for equipment for the folks in the community. I think historically, perhaps there was a place in the courthouse, and I'm sure that there's going to be a place in the courthouse if it's needed. But given the pandemic, these may have to be done by telehealth, and I don't know if there's a need for equipment costs to provide those folks in the community a place to do those evaluations. But there's currently, and this is as of yesterday, there's approximately 130 evaluations waiting to be scheduled. There are 3 Vermont-based evaluators. My understanding is that the Department of Mental Health has contracted with InnovateTel, and I may be mispronouncing that, and they're providing 5 Vermont licensed psychiatrists, and those evaluations will be done only through remote technology, not in-person examinations. And I wanted to raise that, Senator Sears, because I don't know if there's going to be a need for funding to address the issue for the remote technology. it wouldn't be an ask, certainly from the Attorney General's office. I'm assuming it would be from the Department of Mental Health, but I'm even unclear about that. But I want to raise this.
Well, I guess what I'm going to ask is that you put something together as soon as possible for the Senate Appropriations Committee. I'd happy to carry that. Maybe if Matt and Pat and John Campbell and perhaps Morning Fox over at DMH could all get together with a proposal. I know there's a bill in Senate Health and Welfare that came over from the House that would study cross-border telehealth, mental health, and that may also be of interest, where you could hire somebody from, say, New York to do a competency evaluation.
Happy to do that, and we'll convene a meeting and present something to Senate Appropriations, hopefully by early next week.
I hope so, because I don't know when we're voting the bill out. Alice, you have a question?
Wondering, approximately 130 persons who are waiting.
Yeah.
I'm assuming those are all people who would not admit themselves voluntarily. Is that the case? Or does a person who goes in voluntarily also need an evaluation?
Yes, it would be both, Senator Nickda, and it would be based on that initial evaluator. The court can't order anybody to be held inpatient, if you will, without that recommendation from the evaluator. So out of the 130, I don't know how many folks are currently being held versus how many are in the community, but it would be a mix. And I don't know if Defender General Valerio knows that or not, but I think all these issues, we need to get some answers and move relatively quickly on this.
I agree.
I should ask somebody, I mean, I guess the question still is, apparently none of those people are willing to go in of their own volition. Is that right?
I don't think I can answer that.
I think that, yeah.
I mean, can one go in, of that group, can one go in without this evaluation? If their family could convince them to go, for instance.
I think we're talking about two different things. One, we're talking about the Attorney General, Alice, talking about competency evaluation to determine if they're competent to stand trial.
Oh, okay.
And so some of those individuals are held, are incarcerated awaiting the evaluation. Others are assumed in the streets. I'm sure that if they voluntarily wanted to, I don't know how they would do it, but is that, Matt, is that the situation?
Yeah, that's correct. I mean, nobody's been adjudicated at this point. They're just waiting an evaluation to determine whether they can be part of, be subject to the criminal justice system's jurisdiction.
It goes back to S3 in our effort to also divide the two questions. One is the competency and then the other is insanity. But we're talking, these are competency evaluations, correct?
Okay. Thanks.
There was a second issue, TJ,
yes,
that you had?
There was, and this is a little unusual, Senator Sears, but I think it's a request that is in the interest of our state. It's in the interest of the public health of our state. And as I always said, a healthy community is a safe community. The Vermont filmmaker Bess O'Brien, who you all know, who I love to say is the Vermont's storyteller and truth teller, certainly on the opiate epidemic with The Hungry Heart, and certainly on our criminal justice system with the film Coming Home. She's really raised many policy questions through her work in which the Vermont legislature has dealt with. She has a new project, and it was announced at the State House pre-pandemic. I can't tell you when, because I think like many of us, I think anything before March of 20 seems like a different world to me. But it's called the Listen Up Project. And the governor was there. I was there. I think maybe some legislators were there as well. And the Listen Up Project is essentially a play based with Vermont high school students about all the challenges and the complexities that Vermont teenagers are facing, even in the best of times. Obviously, now it's about all these issues on top of all the complexities of the mental health, the stress, the anxiety, now coupled with COVID, which I think, we've had issues with real issues in the rise of mental health concerns, obviously substance abuse. And Bess O'Brien is creating this project, and it's a project that's going to tour the state of Vermont, as she likes to say, almost this anthem of this next generation coming out of this incredibly difficult time that's going on in our world, even in the best of times, but now, of course, on top of COVID. And it will be filmed and distributed to all Vermont high schools. And she's raised a bunch of money, but she is looking for an appropriation of $25,000 to finish this project. I think, are gathering at Linden State College, Senator Benning, this summer to basically rehearse and get the play ready. I think in August, they're going to tour the state in the State House lawn in Montpelier, I think in Norwich, I think in Putney, Senator White, I know in Shelburne. And then it's going to be distributed to all schools. And it's this anthem of the complexities that our teenagers are facing. And, I think about what COVID has meant for all of us, but in particular, young people who are supposed to be enjoying really the best time of their lives. I keep thinking about those high school students who are juniors and seniors and college students, and how difficult the world is, but how much more difficult it's been because of COVID and the social isolation. And I think giving voice to those experiences through art, lifting up the voices of Vermonters, Vermont teenagers, and letting people know that it's okay not to be okay, is something that is in the interest of our public health, which is in the interest of our public safety. As I said, Bess O'Brien is a Vermont treasure. She tells these wonderfully powerful, heartbreaking stories about our fellow community members in an effort to raise awareness, so we can make the world a better place and more fair and more equitable for so many of our community members. And that's been her track record. And I talked to her this morning. She's happy to talk to the committee. I happen to be talking to her tomorrow. And I said, I'm happy to talk to Senator Sears. I know there's some COVID money, and this certainly is an anthem about some of the social isolation and then the mental health impact that's impacted all of us, but particularly young people. And to raise those voices up, I think, is a worthy endeavor. And I wanted to bring it to your attention, Senator Sears, to this committee's attention, and happy to ask Ms. O'Brien to appear. I sent Senator, I think, a little paragraph from Bess yesterday to you, and would really urge this committee to consider the request, and happy to answer any questions.
Could it be funneled through your office?
I don't see why not. We can figure that out. I want to be clear. The Department of Health has given some money to Bess for this project. I think she's raised, and I think this is in it, maybe $450,000. I think she's trying to raise the last 25. And this program for the Vermont kids that will be, I guess, part of the production, whether they're the actors or, stage managers, they're all going to be at Linden State, I think, living up there, room and board free. And so this is a program for Vermont kids that's going to be free of charge. And of course, the impact is going to be felt by, I think, all of our state, but particularly all these young people, because it's then this play, which we turned into a film, I guess, will be distributed to all Vermont high schools. And we're happy to be part of the funding mechanism, Senator Sears, to answer your question.
Thank you. Any questions for the Attorney General? Senator Benning.
Just a comment. TJ, next time you're in the area, you want to remember there's no such thing as Linden State College anymore. Over my objection, they changed it to NVU Linden. So if you're campaigning over here, you want to be on top of the local vernacular.
Thank you, Senator Benning. I revert to the old days of saying Johnson and Linden. My apologies.
I agree.
I think it should have been named Lyndon Johnson University. Anyway, thank you, Mr. Attorney General. Appreciate it. Any other questions besides the? I guess I'll turn it over to Pat Gable now.
Thank you, Senator.
She's only requesting 13 million. As opposed to your 25,000.
Thank you.
TJ is a very persuasive person. If he wants to support my millions, I'm happy to do that. So I want to thank the
Pat,
committee.
I don't mean to make light of because this is a really serious problem that we all face. And, at Joint Fiscal this morning, there was a discussion of the problems that tenants are facing, not being able to pay their rent and not being able to pay their utilities, et cetera, due to the pandemic. And then on the other hand, problems that landlords are facing, not getting enough money from their tenants in order to pay their mortgages. And in some cases, tenants doing damage to their property and not being able to evict, not being able to deal with it. So just a huge number of problems that will come eventually to the court system and just continue to exacerbate the backlog we already have. So I appreciate your putting this together.
Thank you, Senator. And for those who might be watching on YouTube, the proposal is, I think, on your committee page now. It's interesting, before coming in to testify this morning, I sat down with my team to say, we really need to take a look at what we know from our statistics within the judiciary. What's the picture that's being painted? And I'll talk about that in a minute. But we quickly realized that if you don't have time this morning, but if you want, I can come back at another time. When we looked at the graphs that were created by the pictures that are being painted of the different case types, it really looks like a roller coaster. And I would say it's a really apt metaphor for what we've been facing in the justice system and what we've been facing with the pandemic. And so the overall picture, if you looked at all case types in general, was that before the pandemic hit and before the judicial emergency was declared, I think we would say, for the most part, there might be exceptions with a few case types, but our case types generally were, tracking at a pretty regular rate based on, let's say, FY19. And then we were, a little more than midway through FY20 when suddenly the pandemic hit and the judicial emergency was declared. And you can actually track that at that time, suddenly our filings went down. And so although we talk about filings a lot, we don't normally talk about those as the most important statistics. But because we were just at the cusp of rolling out our electronic case management system at that time, we have these two different systems, right? So we are still in the process, because of the pandemic, of putting those together. So the one things we could track well were the filings. And what we saw is, as the state closed down because of the pandemic, all the filings closed down, with one exception that I'll mention in a minute. And you can actually watch the graph undulate as the filings are down, we're all closed down. And then around the summertime, people started feeling a little more open. We were able to open windows, the numbers were starting to come down, and the filings started to go up again. And so the filings were, in general, going up till about through September, I think. And then we know we started having the Halloween, the Thanksgiving, the Christmas shutdowns. And once again, the filings dropped. And so I think as we think about what is the backlog, there are two different parts of the backlog. One is the backlog of what we have not been able to do in the courts, and what we think we can move better with some of the requests that are in the proposal. But the other is this backlog of people, number one, I think, feeling comfortable to come into the court itself. And as you know, only emergency filings have been emergency in-person hearings. Emergency in-person hearings have been taking place in the building. For the most part, we've been adapting to remote technology. But the other thing that I think we can see happening is what's happening in the human lives of people who end up in the court system, and what's happening in the human lives of people who might have mental health issues. What's happening in the human lives of people who have civil cases of some kind, but those cases are not being brought forward because their businesses are closed. What's happening with private counsel? What was the extent to which they could actually be conducting their business in a normal way, particularly in the early parts of the pandemic when we were all still working together to try and find ways to be remote? So in general, that's sort of a big picture. And then I'll just mention a couple of particular kinds of case filings because it includes the question of evictions and foreclosures. And as you know, unlike some of the case types, it's never been, people have always been able to file. There's nothing in the court system that has stopped anybody from filing any kind of case from the time the pandemic hit till now. And yet still we've seen this undulation. So in the criminal division, we looked at FY20 and we compared it to FY21, which is when the pandemic hit. And those like felonies added, for example, in FY20 month to month, probably ranged. The lowest for some reason was in April of 120. The highest was in October of 2019, 333. They all kind of averaged in the 200 somethings per month. In the post, I'm just pulling up the thing here. So in the post judicial emergency, the number of felony charges filed pretty much, it's interesting, stayed the same in the early part of the year, but then went down in November and stayed down through February. So they're only now just coming up, and I'm sure John Campbell will be able to explain that one better. On this misdemeanors, again in FY20, again, for some reason, I don't know why, April and May looked a little lower, but
Yeah.
in general, we had something really high in July. And so I'm not looking at the screen right now. I'm looking at a graph.
Sure.
So if you want to
I
talk to me.
appreciate all the background, but I think we're all convinced that we've got a problem, and I've got a certain limited amount of time to hear from the request. So if we could get to the meat, I understand where you're coming. I think we're all
Right.
familiar with the problem that we're facing, and I think you outlined it well. It's like a roller coaster on filings, but
Right. And so
it was
let me just mention
interesting.
the one.
Yeah.
Yeah,
Please,
I've mentioned
go
the
ahead.
one exception. The one exception to that is relief from abuse. And we wondered what was it about relief from abuse that meant that we didn't see that same kind of roller coaster. We pretty much saw that continue. And what we realized is, for other reasons, we already had adopted a remote proceedings policy for relief from abuse before the pandemic. And so because we already had the procedures and technology in place for relief from abuse, those cases didn't go down in the same way the others did. And so that is kind of a lead-in to the proposal, which is, and again, you'll be able to read it during your leisure, but essentially the proposal identifies different areas where we would like to hire limited service people to help us get up to speed in addressing what we expect to be a surge of cases, not because they're filed in our courts and are waiting for us, although certainly all cases waiting for jury trials have now been waiting for a year, but the cases that have not yet even been filed. And the important part of the limited service positions request is, number one, we're asking to extend the limited service positions that we were granted with the money last year from the CRF funding. And many of those are the positions that have supported judges and litigants in video remote and audio remote hearings. We've also asked for additional positions, and these positions enable us to interact, again, not only with service to people working remotely or in the facilities in the judiciary, but also supporting external players such as unrepresented litigants, lawyers using e-filing or needing to interact on the video and remote hearings. And we recognize that these are one-time monies that we can use over a period of several years. And so we've built into our request for these positions a 12-month period where we phase the positions out so that at the conclusion of the spending of the one-time money, we're not left with a significant resource cliff where suddenly everybody's relying on a certain number of people doing a certain number of things in the judiciary, and suddenly the one-time money is gone and we're looking back at our general funds. And so we've already designed the program to phase those positions out. There are a few positions left. I think it's roughly maybe $500,000 that might be added to our base 3 or 4 years down the road. And those are things that we will learn more about in the next 2 years. And our goal is to actually project manage the spending of the money, including timelines and the discipline to plan for the phase out of the spending of the one-time monies. We have
Mr.
learned a
Chair.
lot.
Yes, Senator Brewer.
Sorry to interrupt, Pat. That was exactly my question. So I'm looking at your memo and I'm looking at the limited service positions for the retired judges and the docket clerks and the court officers.
Yeah.
And I think I see what you're talking about, which is in year 4, we go down to half the amount. Years 1, 2, and 3, 22, 23, 24 have X amount, and then FY25 has half of X. And I understand that you're calling that the phase out to prevent the cliff. My question is, so we have this big backlog. We've got 3 years at the same funding and then a 1-year phase out. What is that based on? For instance, could it be a 2-year full funding and then a 2-year phase out? Is there a calculation based on the number of cases and the time it will take that caused you to reach that 3 at full one-time funding and then 1 year at half? Just curious about that.
Yeah, so it's a good question because there is probably more we don't know right now than what we do know in terms of what we'll be facing over those years. But it's a little bit of a rough justice planning. As a practical matter, the combination of our now being in our trial courts completely now on the electronic case management system and e-filing, which is one kind of technology, and also we're still standing up our remote video technology, including the different ways that we're going to try to support litigants and others who may not necessarily have either the bandwidth or the hardware to participate. We're in the process of that now. You can imagine that what trial court operations looked like, say, a year and a half ago, and what it will look like in the coming 2 years has changed quite a bit, which means that the kind of skill sets that we need to train our employees to do, the kind of skill sets that we'll be looking for in terms of recruitment and the like, will be evolving very rapidly. And so we will always, as we always do, get vacancies throughout that period. And one of the things we will be looking at as a vacancy is created in a position, we will ask ourselves in almost every case, is do we fill this with the former position, or should we be using this vacancy for a position that's suited to a change in need? And so we will actually be doing this transition right from the beginning, which means that we know that in the first 2 years, we will be trying to relieve incredible stress in the system. We knew even before the pandemic hit that FY20 and FY21 in particular were going to be the hardest years for the judiciary because we were running 2 different systems with one workforce. And so we already knew we were going to have a hard time. And then like 2 weeks after we started the beginning of the first rollout in the Windsor, Wyndham, and Orange regions, the pandemic hit. And with the exception of those limited positions that we were able to hire with CRF, we still have only the same number of positions. And so we will be able to plan, if we're granted this request, which really was very carefully thought through, we will be able to plan now to start making those changes and to looking at what works and what doesn't work. And so it could well be when we get into the second year that we might be able to start doing that phase out in the third year because of the combination of, just natural vacancies that get created and what we've learned. But we didn't want to short circuit ourselves because we don't want to be in a position where we terminate permanent employees. We've learned in the judiciary, we've never really, at least since I've been there, had to do a layoff to deal with change. Instead, what we've tried to do is use natural attrition, to constantly step back and say, are we still, hiring the right skill sets and bringing, the right kind of positions into play. And that would be what we would be doing, but knowing that we had that funding there would enable us to do it, in a thoughtful way.
No, and I understand that, and I understand the scale of the need. I guess I was asking because in appropriations, we haven't seen a lot of this, which is funding over a 4 or 5 year period from the one-time funds, which is, it's not just a substantial commitment this year. It's preferring those requests out for the next 4 years or 5 years. So, but what I hear you saying is that in a certain sense, this is erring on the side of caution, and that you might be able to ultimately use less funding if things work out properly.
Right. And that is why we want to use formal project management to do it. In other words, there's just a tendency to not force that discipline. And so we think that we really need a pretty structured plan in place, to do that.
Yeah. May I just ask a question of Stephanie Barrett if she's available? Stephanie, in budgeting for more than one fiscal year, I know we can't tie, it'd be our intent to do this, but would we put this entire appropriation in this year's budget, even though it goes to FY25, or would we just approve the FY22 with a plan to go through the same motions in 23, 24, and 25?
Well, there's options for doing it. The only place you normally appropriate 1 year ahead is in the Pay Act. And you didn't actually do that this year. That's why the Pay Act for this FY22 is in the budget bill. But the source of funds, you could appropriate the entire amount in FY22 and it would just carry forward until expended. You would, put that language in. That's one way to do it. So that's the assuming that it would be ARPA funds, ARPA state relief funds, you would appropriate it all, allow it to carry forward. It would have to, be used for the purposes that are consistent with ARPA and within the time frame of ARPA, which is halfway through FY25.
Okay. So this could be done building the whole.
You could do it doing the whole thing. We have done things where we have appropriated the dollars, but then not allowed them to be, a portion of them allowed to be expended. And then the next portion has to take a second legislative action, because we want to understand, or, the plan's not clear yet, but we've set aside the dollars. We've done that. Those are options of ways to do something that's a multi-year project with the appropriations, as opposed
I imagine in hiring people for temporary positions, it would be easier to hire them if you could say, we're going to have you on board until, I can't think of the day, it'd be January of 2025. Right?
Yes, and that is one of the reasons why we hope that the legislature will
I'm
appropriate
just
all
trying
the
to
money
find out if
now.
we can do, I understand that, and it's a great idea. I'm just not sure we can do that to bind a future legislature. So Stephanie just showed us a way to do that. I'm going to, I want to make one announcement. I had scheduled this to end at 10 a.m. And obviously we're not going to get to John and Matt by then. So I'm canceling S103 at 10:15 to give us a little extra time to try to get through all this. But we are giving advice to the Appropriations Committee to do with it as they wish. Senator Benning.
This is not really a question for Pat. It's more a message to my three colleagues on this committee who are on appropriations. While I can appreciate the predicament that the court system is currently in, if you provide relief to the court system, and I'm not suggesting you shouldn't, but I hope Matt and John Campbell are listening very carefully, because as the stress is relieved in the judicial system, there is a corresponding ripple effect that is going to be translated down to those of us who are also trying to keep up to a court system that's now moving at greater speed. And I'm specifically referring in the criminal arena to prosecutors and to defense attorneys who are going to be expected to catch up with the faster moving judicial system. So I'm hoping both of those guys are listening well and are prepared to make some kind of a statement about how to react for compensation purposes.
Well, if they aren't today, I think that's an excellent point, Joe. That's one of the reasons that I invited John and Matt to join us this morning. My internet connection is unstable, so that was my fault. And the House put 150 million in for internet. I hope mine can become stable if we put 150 million in. But Joe, you froze at the end there, and I don't know if it was on your end or my end. But I think what you were pointing out was that if you put a huge amount of money into one piece of the criminal justice system, it will bulge out at another point if you don't do similar work.
That's exactly the point.
And I'm hopeful that Matt and John, if they don't have those, those types of proposals today, that they will have them by the end of the week or early next week when we're marking up in judiciary. I mean, in probes. That's a really excellent point.
And Senator Sears, that was the.
Especially with your proposal to have night court. That
I know, I got a little pushback on that one.
Well, I don't know. Joe doesn't like the vision of being there at 11 p.m. at night to do the night.
I've given up any plan of vacations for the next 3 years.
Anyway, go ahead, Pat. You may want to
Yeah,
respond.
I was just going to say, because we have shortened time, I wasn't able to expand on that, but that really was a part of my point, is to demonstrate that this particular backlog that we're talking about really deals with parts of the justice system in the broadest sense that are even precede the filing of cases in courts, and that we're going to have a very good collaboration with those, obviously, state's attorneys, public defenders, private lawyers, and also those organizations that support unrepresented litigants, because having the resources for us to be able to hear cases is only helpful if the other people involved are also able to participate. And so I think if the legislature does authorize these funds for us, that we'll want to be having regular meetings with the other players to, look at the more micro parts of these innovations that we'll need to put together.
Well, I think they also that, the example in Brattleboro where you had a trial set and all those settlements occurred, that you couldn't even schedule a trial because the state's
Right.
attorney in Bennington County didn't want to send her deputy over for 24. I guess it had to stay there in Brattleboro because of COVID restrictions, and that things got messed up. But you couldn't even do a jury trial because so many cases settled with the idea that there was going to be a jury trial.
That's correct. So as you know, we are able now to do jury trials in some places. We're still trying, and we still haven't done one yet, but we're still trying.
So, I don't want to rush this, but at the same time, I want to make sure we have time to hear from Matt and John and Stephanie. Are there I have no idea how you came up with the numbers for the IT stuff.
So and for people who haven't had a chance to look at the report, you'll see it summarized at the end. So what we did is we went into each division and did the evaluation of what the costs would be. Unlike our request last year, which was mostly for the purchase of technology, in this case, although there are additional software and hardware components to our request, most of these are dealing with limited service positions we need to move it. And as I think the legislature appreciates, when you give us a generous appropriation such as this, then we need to have the people who can go forward with the hiring and the training and the managing. So we're really eager to move forward on this plan if the legislature agrees to appropriate the funds to us.
Any questions for Pat on how to move forward with this? Senator Baruth first.
And it's not so much a question. I just want to make clear my own hesitation. Again, I'm completely understanding the need for this, but here also it's broken out over a 4-year period. And so we're okaying 4 years of spending in terms of IT. And that makes more sense to me in the case of the limited service positions, because you're staffing up and you're going to need that staff in place. But I'm wondering why the 4-year breakout for everything. And I understand it's one-time money that will be dispersed over the 4 years. It's just we have a million different requests, and nobody else that I can think of is asking for multiple years in the same way. So that's
one of the things I could propose, because even though these are not capital expenses, right, these are operating expenses, but one of the things we've done when we've had a major capital appropriation is we come back on a regular basis and report to the committee and we
Mhm.
report to the committee, you know, where we are on our timeline and where we are on our spending and the like. And I think that's something that we would be totally prepared to do. So we could have a, you know, an annual report to the legislature about, you know,
Yeah.
and maybe it, depending on when you do it. So it might be, you don't want to do it too soon because it'll be too early, but maybe in the middle of the legislative session, we come back, but before you've finalized, you know, your a big bill each year, to talk about where we are and how we've used the money and how we continue to plan to use the money. And that way, we would then have the ability to hire people and give them some assurance about a timeline. But on the other hand, you're able to work with us in collaboration so that if we see there are changes and we may not need all those funds, for example, you know, in past years to deal with those things, there's always a possibility of doing a, you know, a reversion if it looked like we'd been appropriated more money than we were going to end up needing.
Good
Thanks.
to know. Thank you. I will leave it to Stephanie to figure out how to write this, but I am, I think that the important thing is that we can commit to an orderly transition out of pandemic for the judicial branch of government, as well as the associated groups like the defenders and the prosecutors and the defense bar in general, the bar association. So I think all of them have asked this. I would suspect that probate may also be backed up. Is this allowing anything into the probate courts?
Yes, they're part of our courts, and that's one of the details I was going to mention to you. Unlike the other dockets, probate has actually been up. And I really don't want to speculate about why that is because I'd just rather not. But the probate docket has not fallen. The probate docket is actually rising.
Right. Any other questions for Pat? All right. Stephanie, do you have enough?
Yeah, I do, I think, but I mean, it's just a decision of the Senate Appropriations Committee of whether or not you want to. Yeah.
Well, I would like to try to phrase our recommendation is that we support the rollout, the 3.5-year rollout of use of the ARPA money. It may come that when we see the actual details, and then if there's an infrastructure bill, that some of it may go to different sources of funds, by the way. And,
Yeah, and I should mention that courthouse improvements are not covered in this plan at all,
right, but
because we
might be-
anticipated that in a, you know, in a capital fund.
Right. Committee, are we ready to recommend that this proposal?
Yeah, I guess so. It's a little hard to, I guess it's the Appropriations Committee that will have to weigh all the proposals that are coming and how to juggle them.
But
I'm happy. Oh, go ahead.
Go ahead, Senator.
I was just going to say, I'm happy to recommend this into appropriations. And then when we have the discussion there, I will want to ask about the extended timeline of it around the, are the limited service positions in the IT, do those drop off after 4 years?
So the limited service positions are in all different parts of the judiciary. And so because there are different backlogs that we're dealing with, and we are managing them in different ways. So at the end of those years, I think we'll probably see more positions that are technology oriented. and fewer positions that are paper oriented, I guess I would say.
But what I'm wondering is, as I understand it, the retired judges who are being brought back and those clerks to staff them, they're limited service and that drops off after 4 years.
And I would actually expect that probably those to, that's a very small part of the ask. So, assuming that we've gotten through the backlog by then, that piece of it might fade out a little sooner.
Right. So my concern, if I have one, is that on the IT side, we're hiring a number of people, and we're committing 4 years ahead of time to keep them on once the one-time money goes away, unless I'm misunderstanding what you're saying.
Yeah, so what'll happen is we don't completely end up at zero in our plan at the end of the day. I think there's, as I said, maybe $500,000 added to the base at the end of the day, anticipating that at that point, the kinds of demands on the judiciary that we're seeing grow will continue. And the kind of demands that have grown in the last 5 to 10 years aren't just IT demands. There are big data requests that are now expected that we were never resourced for. We don't even have a data analyst in the judiciary. And so when you look at what the legislature and others are looking for in terms of accountability and transparency in the judiciary, we need to do a much better job at like 4 years from now, doing those kind of.
I understand. I'm just signaling my concern that I think it's a discussion we need to have further in the other committee, whether we want to greenlight spending over a long period of time with the understanding that we are in effect going to be growing the base 4 years out. I don't know if $500,000 is the whole of it, or if it will wind up being more. So just being upfront that that'll be a concern I share there, but I'm happy to vote this out as it is, as a recommendation from this committee.
One of the things that on page 5 of the report that I found astounding, I should have known, but I didn't. As a result of the pandemic, 15,146 expungements that the courts began to process in October of 2019 under Act 8. Of those, 5,695 cases remain to be expunged. And then you have an additional 5,332 marijuana conviction charges yet to be pursuant to Acts 167 passed last year. And they're also anticipating an additional 1,200 petitions filed in the criminal division since April of 2020. And those are astounding numbers of a backlog. And I can imagine that without this money, I don't know how you'd ever get through all of these in a reasonable amount of time. And then as more petitions get filed, the backlog just grows. So I
That's
think
correct.
once I take solace in the fact that once this backlog is dealt with, that we won't see this kind of huge backlog in the future. This is kind of a temporary thing. And so if some of this money, limited service positions, can help to get rid of this backlog, I think it would take care of. I just don't think there will be that many in the future.
Well,
Yeah. Oh, go ahead.
if I can just weigh in from the employee's perspective, limited service means just that, limited service. It doesn't go on. So it doesn't add to the base because it is for a specified time period.
Well, on page 4, if you look at that chart, we're hiring a senior IT manager, help desk specialists, infrastructure services manager, data services manager. My question to Pat was, would those positions go away after that? I understood her to be saying that they wouldn't. And so they're not really planned as limited service. They're planned as being made permanent ultimately.
But may I
Have-
clarify that, Senator?
Sure.
Yeah, please do.
Yeah, in the judiciary, I have an authority that's similar to the authority of the Secretary of Administration in terms of how we manage vacancies. And so I do have the ability to convert vacancies from one kind of position to another. And so although many of those positions will remain, the total number of positions in the judiciary will not necessarily be added by those. And
Well,
so,
and if there's no reason why we couldn't put in language asking that if those positions are continued, it's a function of what you're talking about, of filling vacancies. And that would certainly make me more comfortable with it.
yes, and that's why when we showed the end the last year, I didn't want to show us just spending down to zero, because I think in 4 or 5 years, as I said, the expectations of the judiciary have been growing. So I wanted to be realistic, but that would be the plan, is that as attrition takes place, normal attrition, not forced attrition, normal attrition takes place, part of our project management is to sit down with the senior executive team and say, all right, you know, what's working, which skill sets do we need to keep on board, and then which skill sets have been, you know, replaced by you know, a new opportunity. So we've found, as I said, in the judiciary, that works well. We're not you know, the people who have been devoted to us and have worked for us for a long period of time, we hope many of them would, you know, move to new positions that were created, would be able to train people, and, you know, they would be able to evolve. And so it's a way of having a very respectful transition, notwithstanding the pandemic and the sudden move, you know, to video remote and the like that we had to do.
Senator White.
Can I just add that in response to Philip's concern is that if the judiciary at some point wanted to make these limited service positions permanent positions, that other than filling them through current positions that are where people have left, they would have to come back to the legislature to add new positions. So they can't just say we're going to make these 5 positions permanent now, unless they're using slots they already have.
I understand that, Jeanette. I'm just saying that Pat's testimony was that I wanted to make clear, at least speaking for myself, my own sense that I would not be voting to okay positions that were expected to continue without a discussion of that in appropriations, because this does look, the other one had a step down plan to get rid of the limited service positions. This one doesn't have a step down plan really. As Pat's saying, there's a more a plan to absorb these new positions into the department and hopefully to phase out other positions to account for it, but not necessarily was your phrase.
Can you provide us with a memo on specifically on the IT positions you currently have and how you see these being melded in? I don't know, meld is the right word, but how you see these being accommodated within the current IT and what you might see in the future?
Yes, I would be happy to do that.
I think that would help answer the concern that we just heard. And Stephanie, do you have questions or do you have enough for?
I don't really have any questions. I think it's just a matter of, once the decisions are made, drafting it, depending on what those decisions are.
Well, I'd like to recommend that we support the proposal contained in this proposal dated March 15th. and recommend it to the Appropriations Committee.
Yeah.
With the understanding that we would try to accommodate other areas of the justice system to make sure that they are not overwhelmed by this. Senator Benning?
Your last comment sort of answered my question. I just want to make clear, I fully support the concept of spending this federal money to relieve the backlog in the judicial branch of government. But I feel like we're crossing a line into the Appropriations Committee's conversations about how that's actually going to happen. But I want to make sure I'm in lockstep with Philip about what long-term concerns are. But I want to make sure in saying I'm in favor of this, part of the package of being in favor of is making sure those outlying entities are also addressed.
I agree, but I've noticed as a member of PROPS, and I'm sure Senator Nichter and Senator Baruth have as well, we've had numerous requests from both health and welfare and particularly economic development for spending huge amounts of money, and how, you know, their recommendations are taken. Sometimes the Appropriation Committee supports their recommendations, sometimes there's changes made. But as far as I'm concerned, we need to do something to help this backlog. So, is there any objection to the recommendation?
No objection.
Thank you so much, Pat. Maybe you can stay tuned if you have time, and Stephanie, I hope you have time. We'll try to hear from Matt and then John Campbell next. Matt, are you prepared to?
Are you taking a break?
I wasn't planning on it, because I wanted to get to, then we would take up the bill at 11. I was planning to take up the bill that was scheduled 145.
I'm going to make
not 140. I'm sorry, 128.
28.
I'm going to just do my switcheroo right now. I had told before you came on, I'd said that at 10 when we had, I thought, a scheduled break, I had to go to my other room so somebody else could use this one. So
Okay.
I'll be right back.
All right. We'll see you shortly.
Yep.
Thank you. Matt, please.
Well, I have kind of scared of this this whole situation and this and how to respond to it. We're always in a position where we have to respond to whatever somebody else is doing. So in the event that, you know, one part of the system, whether it's law enforcement or prosecution or the courts, get grant money, then we are always in the we're always in response mode. I understand the need to get at this this backlog. I will just tell you what my concerns from the Defender General's system point of view is. We have extraordinary difficulty hiring anybody under normal circumstances right now. You know, we'll pick up one person here or there, but I've long felt, for a couple of years anyway, that we've tapped out the number of people who want to do public defense work and are available to do public defense work. And so in response to possibilities like night court or weekend court or the like, I'm concerned about getting people who are willing to do the work more than anything else, whether it's the people who are currently in the system or the people or whoever it might be who's out there who's looking for work. This is kind of compounded by what I've experienced in the last month or so, which is a lot of retirements from and departures from the public defense system. We talk about pension reform and the like, has hastened, I think, the departure of individuals from the public defense system before they, if you know, on the staff side, whether it's investigators or admin and probably attorneys as well soon. And, you know, I think that the biggest concern that I have is just being able to respond with enough personnel to cover the time that the court wants them available. I'm concerned about maybe having to pay people double time or something for after hours work or for, you know, weekend work. And I'm, you know, as it is, the people who are working full time are typically working 50 to 60 hours a week in staff offices anyway. I just have concerns. I don't know exactly what the answer is or how we are going to respond to it. I mean, we'll have to come up with something because that's what we do. But you know, in recent years, I've had openings in Rutland that one of them was open for 2 years and I couldn't fill it. Finally, I got somebody who I was able to fill, and I have similar problems in St. Albans. I guess if everything was in Burlington, Montpelier, I wouldn't have as many problems. But in the out, any other counties, and even Chittenden has been more difficult than usual over the years. I'm just concerned about whether there are the lawyers who exist who are ready, willing, able, and competent to do the work at any price. And you know, we're going to have to figure it out one way or the other. But I will say that that's my biggest concern. I'm not so concerned about the technology part of it. We during the last infusion of funds last year, or maybe it's this year, but this fiscal year, with the COVID relief funds, we upgraded our IT systems from all the staff offices and the contractors all had the ability to bring everything they had up to a level where they should be able to deal with anything that the court throws at them from a technology standpoint. You know, clearly the technology has been helping for you know, what we consider as sort of the lesser hearings, the more complex hearings and the like. You know, our folks are definitely you know, concerned that you know, remote will become the way of doing everything, and I don't think that's actually a legitimate fear. But I do think that there's going to be a lot of things that can be done remotely because it's been demonstrated that it can be, and that's fine. So I don't think we're going to see a big technology problem, even with everybody who exists right now. If it is adding some capacity to deal with additional people, if we can get additional people, that might be another story. But I don't see that as a huge expense for us. The biggest issue I see is getting people who are ready, willing, and able to do the work, because that's a problem with the status quo. I also have, yeah, I've been thinking about this, but it's, you know, I've got union issues and, you know, other things I've got to deal with from a staffing standpoint, not the attorneys, although I can, but everybody else in the staff system. is a union employee. So I've got to deal with that somehow too, in the event that they are going to be required to do something on, after regular business hours. I don't have numbers to attach to it because I don't know exactly how this is going to work yet. And I'll have to talk to the state's attorneys. I will be talking to John and TJ as well, about both of these, all of these issues. So, I understand the need for it. I hope we can, we'll get through it, because you just put one foot in front of the other, but I don't know the answer right now as far as what it's going to cost. And even if you threw, if you $10 million at the defense system, I don't know that I could find the people to do the work, even if we had the money. So those are going to be the challenges. Hopefully
there'd be some numbers that we could attach to it.
I think there will be, but I need to do more on it. I didn't really know what the response was going to be to the court's proposal. I don't know what the numbers are, and even as it was with the last CRF funding that came through, I had to return $88,000 of the money back to administration, which isn't a lot because we got 1.2 million or something to spend, but I turned it back because I couldn't find the people I needed to spend it on, and it went back into the pot and has been reallocated. So those are the things that have come to mind for me.
Okay, great. Thank you, Matt. Any questions for Matt?
My apologies.
That's okay. Turning it over to John Campbell then for a few minutes. Of the state's attorneys and sheriffs.
Thank you, Mr. Chairman. John Campbell, Executive Director of State's Attorneys and Sheriffs, for the record. I came in with some numbers to discuss with you and some of our needs, but frankly, just like what Matt just said, even hearing the court's proposal, I think we're going to have to go back and really take a look at how we would handle some of the suggestions and recommendations that they have. One of the things that Matt had mentioned was the night court and the weekend court. And I noticed Pat Gable said she had pushback on that. And I just don't know if they're planning still on going forward with that proposal, because if so, that's going to create a major problem in and of itself. So perhaps we can get a more definitive answer from the court as to whether they intend to go forward with that idea. Both both the Defender Generals and our employees are in the union, and VSEA represents them. And I'd have to review the contract to find out, what exactly, how that would be handled within that realm. And also, frankly, when you're talking about all of the specifics of the case backlog, the expungement issue, that backlog, the fact that we're going to be opening expungements from 15 crimes, I think there's going to be expanded. And then also on top of that, all the data collection that is now being required, or in some of the bills that the House is presenting over to the Senate. If you look at that collectively, I don't know how we're going to have enough time in the day to do a lot of this. Certainly with our current personnel level, we wouldn't be able to do it. As you all know, we are short. We have 5 vacancies right now that we hope to be able to fill. That's obviously on the ongoing general fund appropriation. But this situation where trying to get through the backlog and trying to do it with also dealing with the Odyssey issue that's there, we definitely need more people to actually be able to keep the wheels turning. We've had a couple of our support staff, quit recently because of some of the problems encountering, and people are really stressed to the max, as everybody is. However, I think when we look at all of the additional work, and if the courts are going to be having trials one after another, which again we have to do it. We have to also understand though that the attorneys not only need to have time to do the trials in court, but they also have their own regular case files. And our folks are handling around 350 cases average right now, which is that's at the breaking point. So, Mr. Chair, I can go through what we were anticipating and saying, because we're looking for limited service positions to help with the offices, with all the filing increases that we're going to have there. And when I say filing, it sounds just so mundane, but it's not. There's so many other things that have to be done when you're discussing filing or keeping the cases going. The victims advocates, my understanding is that VSEA wants to discuss that with the appropriations committee, and we were looking to try to get help for them with the limited service, from a limited service standpoint, in order to deal with some of the increases that in cases that we're seeing in the domestic violence and the abuse of children and things of that nature. So I'm wondering if it wouldn't be better if if I had a chance to sit there and discuss with Matt, because I think it's important that we talk, and then also possibly Stephanie, to get a little bit of an idea, a clearer picture of how it would be best to proceed with the request. And also, one of the things I want to just mention too with the IT. We have one person that handles, I believe, almost like 180 people, and there's no way that he can continue doing that, even at the current status. So we would be looking for some additional limited service positions in that area as well. So I'm looking to you now, Mr. Chair. Do you want me to try to give you some numbers that we are looking for, or should we do a little more?
I think if you and Matt and Stephanie can work together to give us some numbers early next week, that would probably be the best we could hope for. I do know you have the 5 vacant state attorney positions that you were looking to fill. And I was prepared to recommend that. I'm not prepared to the Judiciary, up to the Appropriations Committee. I'm not prepared to recommend 14 new victims advocates. I don't know where that all came from. I think something happened. We passed a few bills, and all of a sudden we're being told that we overloaded the victims advocates. I think there needs to be better coordination between the victims advocates in the Department of Corrections and the victims advocates in the state attorney's offices. I think that's part of where the problem lies. But I, frankly, I was disappointed, to be honest with you, that and that reaction, frankly. And I didn't hear it from the Center for Crime Victims. I didn't hear it when we were taking up the bills. So perhaps my saying this on YouTube will send that message.
And Mr. Chair, and I apologize for, because I actually during the testimony and appropriations, I had been under it was my understanding that one of the bills that would put extra pressure, and that it was the mental health bill, but I understand that is not as much, the number that we would have would be really quite small. So I don't think the pressure's there. I do believe there's other pressures there, but I believe that some people have been, have not, I don't think everybody realizes the complexities of some of the issues and how we go about getting appropriations for different groups. Now, the victims advocates, as you know, are grant-funded positions. However, and we've talked about this, I think that it is absolutely, it would be a great idea to at least get a coordinator, a victims advocate coordinator, to be able to help the victims advocates, really determine what their jobs, I should say what their job is. They know what their job is, but to help coordinate it with the other departments, whether it be Department of Corrections or Department of Mental Health, to aid in also in the expungement issue. I think that's extremely important. And then also we had recommended, our office recommended to try to get administrative help to them as well, because there's just a lot of paperwork that they've got to do. They've got to do contact outreach, and we do think that they definitely need some assistance, and it's just a question of how we do it, because again, it's a grant-funded position, and I believe that again, the union VSEA might be asking for something different, so I'll leave that up to them to discuss it with you all. But I believe that if you give us to next week, I'll be able to come back with a more definitive ask and recommendations, and in light of the court's testimony today and review of their recovery plan.
I think that's fair. If you and Matt can work with Stephanie.
Could I ask a question?
Yeah, sure.
I just would kind of like to know about how serious the court is about any after hours or weekend work. If that is a, how much and, what hours and that kind of thing, because that's going to have the biggest impact, I think, on what we need to do.
Matt,
So
can you respond?
Yes, I can. So when you have a chance to read the proposal, you'll see that I make clear in there that we wouldn't do that unless we had been able to work out with the various stakeholders and justice partners a plan that would work. So that could be as modest as just internal to the judiciary, where we have employees on different work schedules who might be working that, during hours that weren't the normal business hours, but they're on a flex schedule. It could be as modest as that, where it wouldn't affect others, to the point where when we were looking at caseloads, if the caseloads were such that we thought some off hours work, whether it be, extended into the evening or on weekends worked, that we would do it. But we would never do that without, having that collaborative discussion with others. And we would really need to analyze it, with a cost benefit. So if we don't have trouble, recruiting people, let's say the legislature grants our proposal just as we've proposed it, and we have no problems in recruiting people, it might not be necessary to do that. But if we got to the point where we felt that people's constitutional rights were at risk, or people were being detained for a longer period of time than was appropriate, then we would want to work with others to do something. But we would never impose that without that kind of change, which would be a dramatic change, I think, in Vermont, though it often happens in other states, without a collaborative effort where we were doing it together.
And the thing that I'd like to say about that, and again, this has to go with the labor issue, and I think the judiciary is the same as far as they have a labor agreement. We probably would have to open up the contract again to discuss that. And you all would have to check with your folks, but that's my understanding is that we would have to reopen the labor contract to.
I think a lot of this, I think the committee is open to anything that you think will help to, I mean, we all know there's going to be a tremendous backlog, and I hear the concern of Matt about hiring, to actually finding attorneys who are willing to work in defense, particularly in some areas of the state. And I think that's probably a problem for the state's attorneys as well. But there's no question that Vermonters are going to be adversely affected if they can't access the civil and criminal justice systems in a reasonable amount of time once the pandemic, say next, hopefully July 4th is that, for example. The governors hope to come back to normal. And so let's say that people are, gearing up. By September, we're going to need to be able to handle a deluge, I'm afraid. And I don't want to see it that we're backed up in the correction system, we're backed up in the civil system with people with evictions and back rent and back. There's just going to be so many different situations. And so I'm hopeful that we can work something out. I appreciate, John and Matt, your concern, and I'm prepared to try to help in any way I can, to try to help both your departments to deal with what I'm sure is going to be a huge influx of cases.
Well, we
And
appreciate that. And
yeah, in the budget itself for FY22, we have a number of outstanding issues, particularly the state's attorneys and the defender. I don't know so much for the judiciary in there. But I've got them all right here. I was a little confused about the actual dollars. John, if you could get me the actual dollars on the 5 vacancies for the Addison, Franklin, Washington, Caledonia, and Wyndham.
I will. I see what we have here in this list, but that I'll recheck that and get you specific numbers.
Where is Addison?
Where's what? I'm sorry.
Addison. That's somewhere south of Chittenden.
Yes, I believe it is. Do you remember
okay.
Senator Ayer?
Oh, that's right. Yeah, that's right too. That's where it is. Over on Lake Champlain.
Yeah, it is. But yes, I'll have those because it says here, yeah, because it is 5 positions, not 4. So I'll get that number to you.
Stephanie, any comments? Can I help you? Or have we just doubled your workload?
I'm sorry, I had to take a call from Jane for part of this, but it's the same as in the judiciary. It's just a matter of what your committee is recommending and then what Senate appropriations in the end wants to do with balancing all the demands across all the sectors.
What we're going to be recommending for the Defender General and the state's attorneys. However, I think I would like to make sure that the funding is there, that Senator, the Attorney General brought up the 130 people who are awaiting evaluation for competency to stand trial. That needs to be dealt with somehow. And I don't know if Matt or John have recommendations there, but I think
a quick question.
Yeah.
I don't know what the normal pending number of competency evaluations is out there. I know that the Department of Mental Health has had a departure of a number of the people who have been doing that work for a really long time. And that's been the biggest issue that I think that, they usually had three, and I think three retired or left at the same time. And then they've had other people filling in, but does the court or anybody else know what a normal kind of pending group of evaluations is? Because that number to me sounded very high. I thought the number was much smaller usually.
I don't know, but I agree with what you're saying, because there are the individuals that did. I think it was two people they lost, and which is going to end up requiring us to find, go outside of the norm. And it's not that we have a tremendous number of folks that do those within the state either. So, and same thing with experts, that we're going to probably have to go outside of the state, which was going to increase the expert budgets, I think, for both of us. And of course, the state.
I understand that mental health has now hired some people. That's what the AG's office advises, but I guess this is something we'll have to work out. I didn't know what the normal number is, but that sounded really high to me.
Got it. Yeah, we can find out how many are being detained in the correctional facility awaiting competency evaluation. Seems like this is a problem that's immediate that needs to be addressed. And I don't know how to allow. Are you allowed to evaluate remotely?
I know there's certain tests you can't, but it's actually you have to have that in person. Matt, you probably know better than I am, so I'll defer to you.
We set up in a number of our staff offices during the pandemic rooms where people could socially distance and evaluate. So evaluations could be had in person, and we have actually rented extra space so that they could do that. We also have set up video rooms where in some cases that could be done. So we've done it both ways. One is as I said, so they can be done in person where possible, and then others we've set up video access so that clients could be available to remote people. So you can do them remotely, I guess. But I don't know what the results of that has been. I just know we have the infrastructure for it.
All right. Just gets complex, unfortunately.
So, Mr. Chair, then what we'll do is I'll get together with Matt and discuss with him, and then also with Stephanie. And also, I guess we would reach out with TJ's folks too, and then come back with a little bit more concrete proposal.
Stephanie, can you contact mental health?
Yes, I can. Yes.
You've heard this discussion of the number of cases.
Yeah.
Is there money that they need to close that backlog?
I'll talk to Sarah.
Those generally I would guess about half of them are incarcerated. I
will talk to Sarah Squirrel and Sarah Clark and find out what the historical run rate is too, as well as what they think
that would be really helpful.
The cost projection timeline is.
We took pictures yesterday, Senator Nitka, but I'm going to use your pictures first. If we could ask, I think it was on the state's attorney's budget.
Right. So I sent them to Peggy this morning. I sent 2 pictures to Peggy, so she has them and could put them on the screen, I guess, if you wanted her to.
Yeah.
Okay, hold on.
Not my grandson, though.
What was you saying?
Hold on, let me just pull it up. Hold on. Let's see. Okay.
Imagine us taking pictures with our cell phones in order to ask questions.
Right.
Can you see it?
Yep.
See if I can figure out a way to make it bigger, because it's not like a,
Yeah, it's not like a regular
it's not
document.
like it's, yeah, I don't know if I can, oh, well, there's, can you see that?
Yes. It's quite small, but I can see it.
Is that a little better?
Can you see it, Senator Sears?
No,
Because it's too small, or you can't?
yeah, well, my,
Let me see. Can you guys see it now?
I can. Oh, it's a
why
little.
don't you just, why don't you just read
Same
it?
size.
Want me to just read it? 1.7 million to state's attorney and sheriffs for case management system needed upgrade to SAS case management software. 138,000 to Defender General to complete case management system upgrade. 250,000 to Secretary of State for completion of Vermont Business Portal to
Oh, we didn't
provide.
need that. That's, we were just, the 1.7 for the
Yep.
state's attorneys and
138,000.
138. Do you really need, why do you need so much more than that?
We are going to, and we had Justware, which is and they are no longer supporting us with any safety updates. And so we have to go out to a totally different system. That figure is one that we've been working with ADS on this to review it. They've looked at our system, our situation. They've had conversations with us, with JTI, which is the Journal Tech, which was the company the vendor, and they absolutely concur that we are in a dire situation right now regarding our case management, and that if we don't come up and get into a case management system, then all the interaction with Odyssey and with other agencies we won't have it. So that's that is that is over a 3-year period as well, I believe, or at least that's what.
But Matt, is 138,000, which just seems like so much different.
Yeah, we have found a workaround for, and I think I testified to this in Appropriations Committee. JTI was kind of holding us hostage in the same way that they were the state's attorneys, and we found a workaround with 2 companies. One, and both of those companies, one of them had former JTI employees who are willing to support the JTI Justware program while we move on to our next step. Because I didn't want to be held hostage and forced to just accept anything that at any cost that people wanted to push on us from the outside. And so we're able to basically continue with Justware as it is, with technical support by former JTI employees who formed their own company, and with the remote hosting of data with a company that we've been dealing with anyway. My hope with that, number one, was to force JTI back to the table for legitimate negotiations, as opposed to, just trying to, kind of shove everything down our throats. And so actually it's worked, because JTI now wants to come to the table this Friday and start actually negotiating. But if we were going to continue with basically maintaining Justware as it is for the next year, it didn't cost that much more. It was the 138,000. if we end up negotiating a deal with JTI to continue in a more reasonable way, then that number will be different. But I don't know what that number is right now. So as it is, it has forced JTI to the table, and I may know more about it next week, even after this Friday's meeting. So,
Thank you.
And yeah, and Matt, I would probably, when you're dealing with JTI, I would take a real close look and also talk to ADS, because I'm not so sure that they're going to be in this business for a long time. So
everything we do is in conjunction with ADS. Every meeting we have with them is with ADS, and the e-Defender program that they have is used in over 400 different jurisdictions for public defense. So it's, I think that there's a difference between what's going on with prosecutors clearly and defenders. But in any event, I'm
That's helpful.
aware of them. Believe me.
Yeah.
The state's attorneys also have in the next section, Peggy, if you can't post it, that's fine. The next photo is 462,474 for information technology and other caseload demands resulting from judicial system changes made in response to the pandemic. I guess our question there, John, was, is this money similar to what, obviously it came before Pat's proposal this morning, but is this a similar request that is directly related to the pandemic and would come out of this cycle?
Yeah, and Mr. I would have to concur or confer with Annie on this. I see. This is the first time I'm seeing that. What's on the screen right now?
This is from the House bill. It's been already approved by the House.
I know I wasn't in this office. I was not the one who was following that bill.
Okay.
We've got a whole many other situations that we're following, and so I would have to again confer with her and find out. Clearly, we don't want to have a duplicate. This to be from the request we have here with the ARPA funds.
But also if you make a further request in response to the judiciary's proposal
keep that in
today, to keep that in mind, that that's in the House bill.
Yep, we will do that.
In the base budget, the Defender General received quite a bit more than the state's attorneys. You're aware of that?
I'm sorry?
The Defender General in the base budget. Have you looked at the base budget proposals from the House? As Annie or somebody could respond to that with a memo to me.
Okay. She's texting me right now and saying that it is ARP money and it's only a partial amount. I'll have a memo sent to you regarding that. And what was the part about the Defender General?
The Defender General's funding increase over the governor's recommend in the base budget was higher than what was recommended, over the governor's base budget in order to make up for many of the problems that Matt identified.
I get my news every time I go ahead over the governor's recommend, so I'm gonna have to take some lessons from that.
Well, maybe you should, but
I will have a memo to you by tomorrow, the latest. That's all right.
I guess, Matt's, and I don't have the exact, Stephanie probably has them, but I believe.
About $1 million.
Yeah,
it's just a little shy of $1 million across both lines of the Defender General's budget. It's like 982 or 92 or something like that.
We'll take the Defender General's, and we'll go along with him.
I'm not taking the money from the Defender General.
No, I just wasn't asking that. We'll go along with him and we'll get ours increased too. So. Fortunately. Just a joke.
Well, back in the day when we were in person and we were working, the three of us working together, you know, I gave you $5. I had to give Matt $5.
Those days are there. I look forward to having those come back, actually, where we can actually talk in person, and you can, walk into your office while you're sitting there eating your peanut butter and jelly sandwich for lunch. And
I haven't eaten a peanut butter and jelly sandwich for lunch in centuries.
I had one yesterday.
Good for you.
Yeah.
You still eat your fluffernutters? Alice, there's probably a jar of fluff in the
Vault.
in the Alice's vault as we speak.
That wasn't mine. I swear to God.
Well, we don't know whose fluff it was, but Alice brought it out one day during testimony when somebody was giving us a lot of fluff.
Right.
I can testify, in fact, under oath, that I've never ever eaten fluff.
It was Alice's fluff because we gave it to her because she kept talking about somebody giving us fluff.
You
Yeah.
realize that
Right.
fluff is basically a New England thing. We
Is it?
realize you came from Florida and may not
Yeah.
be familiar with fluff.
We didn't have that down there. Anyway.
I think we'll take a break till 11:15. If the committee
Okay.
could be back, we'll take up H120